Hello, my name is Deborah Gonzalez and I'm from the Law Office of Deborah Gonzalez, Esquire. Today's session we're going to be starting in looking at intellectual property. Specifically, we're going to be talking about copyrights today, where it all begins. And as I always begin as an attorney with the disclaimer, the presentation that I give you today is for educational purposes only and does not constitute legal advice. It is recommended that you seek legal counsel for specific matters. So if you or your client may have a specific intellectual property copyright question and you do not practice intellectual property or copyrights, you probably do want to speak with an experienced copyright attorney. In our session today, we're going to be looking at first a definition of copyrights and intellectual property. We're going to be looking at some of the basics of copyright. I also want to go through some of the history because it's interesting where our copyright laws come from. We'll look at the bundle of rights that make up copyrights, what copyright specifically protects, how you register for copyright, the infringement aspect of copyright, and then some justifications for actually copying somebody else's work or using their work under the fair use doctrine. And we'll finish up with remedies. And the last thing we'll touch on is some copyright issues as it relates to the social media and online world. So the first thing I'd like to do is, as always, let's begin with definitions. And the definitions that I'm going to offer you right now are from the World Intellectual Property Organization, or WIPO. And you do have that link to where I got these in your handout. So make sure to take a look at them because they are a great resource for you and have a lot of information that you can find useful. So WIPO defines intellectual property as that refers to creations of the mind. And then they list some specifics: inventions, literary and artistic works, and symbols, name, images, and designs used in commerce. And that phrase, used in commerce, we're going to see has a very specific connotations. So for WIPO, they actually divide intellectual property into two categories. The first category is industrial property, which includes inventions, so that's covered by patents, trademarks, industrial designs, and geographic indications of source. Now, in our next session, we will be talking about trademarks and trade dress. In this series, we do not address patents, so you do want, that requires a special attorney that has passed the patent bar, and so it's a very specialized practice within the legal area. The second category is copyrights, which we are going to be discussing today. And that includes literary and artistic works such as novels, poems and plays, films, musical works, artistic works, photographs, sculptures, and even architectural design. So that's what we're going to be discussing. How do we protect through copyright those particular visual and pictorial types of designs and works that are out there? Now, as we begin our history for the protection of these particular rights, we actually begin in 1710 in Great Britain. And here is where we have the statue of Anne, and you have a little in your handout, a little picture of the Queen herself. And it's called actually the Statue of 8 of Anne, and that's because this statue was passed in the 8th year of her reign. And here the British Parliament authors the first copyright law that protects authors, and they're very specific as to who an author is. And so the actual official title of this statute is an act for the encouragement of learning by vesting the copies of printed books in the authors or purchasers of such copies during the times therein mentioned. Now, the Statute of Anne's, although it applies specifically to published works and look at authors as those who have written published works, it was also limited by duration. In the Statute of Anne, this protection basically lasted about 14 years, and you did have the option to renew for another 14 years before it lapsed. Now, this statue of Anne actually serves as the foundation for when our founding fathers were developing the United States Constitution. And in Article 1, Section 8 of our Constitution, they wrote that one of Congress's powers is to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So what you see is that though the Statute of Anne in 1710 is really focused on this idea of authors of writings or publishings, our founding fathers in the Constitution actually expand that to sort of include the discoveries and the scientists and what's out there. But it's always based on this idea of learning. To encourage an educated society, we need these laws to protect what that educated society may actually develop or create using their intellectual powers. Now, the U.S. copyright, though we did have it in the U.S. Constitution, that article, which was in the 1780s, it wasn't until 1790 that Congress actually passed the first Copyright Act. So it was the 1790 Copyright Act. And what happens is that, again, trying to define what an author is, trying to define the kinds of items that would be protected all through the 1800s, we have sort of these amendments to the acts, additions to the acts, interpretations of the acts for almost 100 years. So it's not until 1909 that many of those amendments, people are thinking, you know, there's just too much out there. We need to sort of reform the copyright law and bring it, all of those desperate amendments that we have, and bring it back so that everybody can understand. So in 1909, that is what Congress does. It reforms the Copyright Act of 1790 and brings those additions together. Now, from 1909 until 1976, we would not have a major reform to the Copyright Act at all, even though in 1954, the U.S. actually signs on to the Universal Copyright Convention. Okay, and so it's the idea that countries, through bilateral and multilateral agreements, will recognize each other's copyright registrations. It does not necessarily set up an international copyright, and in fact, even today we do not have an international copyright. It is the jurisdiction is by countries. So for some companies like Microsoft, for example, who may be selling software in many different countries, they would need copyright protection in each of the countries in which they are selling the product so that they can have protection there. Okay. So we have the 1976 Act is the next big reform for our copyright since 1909. Now, between 1909 and 1976, there are a lot of inventions that affect what copyright protects. So, for example, television and film and radio and all of these other aspects, including the beginning of computer software and hardware and that type of protection that's required. In 1988, the U.S. signs on to adhere to the Berne Convention. And the Berne Convention, again, trying to help countries sort of standardize their protection for copyright so that an author in one country can be as protected as an author in another country. Again, 76 was that major reform. 88, we get the adherence to the Berne Convention. So the next major reform that we get is in 2000. And this is the last major reform that we've had, and it's embodied in what is called the Digital Millennium Copyright Act, or the DMCA. And you're going to be hearing a lot about that because, again, now expansion has been given to specifically online property, websites, domain names, things like that. So when we started off in 1790 just protecting the rights of authors, expanding that to protect the rights to scientists, to today protecting many different kinds of intellectual property that were probably never imagined back when the Statute of Anne was actually passed. Okay, so according to the U.S. Constitution and the U.S. federal law, copyrights is a form of protection for original works of authorship fixed in a tangible medium of expression. Now that one statement holds a lot of important case law behind it. For one, just what is an original work? Does it have to be original in all of the world, or just original in the US? Or does it have to be original to a particular author? And the case law that we have actually says that it has to be original to the author. The courts do assume that there might be that very rare occasion where two individuals in two very different places in the world may come up with this same fixed expression, okay? But as long as it's original to them, as long as they did not copy it from each other, the court says that they are entitled to protection. The other important thing here is this idea that it must be fixed in a tangible medium of expression. Now, what that basically means is that copyrights will not protect ideas. What it will protect are things that are tangible, things that people can see and experience, but not ideas. And we're going to see some case law as to how that actually plays out. Now, copyright, in fact, is not just one right, but a bundle of rights that's given to the author. And specifically, we have 5 of them. So the first right is the right to reproduce the work, to copy it. Copyright, I have the right to copy my own work. And the law says you can copy, imitate, reproduce, duplicate, or transcribe the work in a fixed format. Now that means only the author has that right, but we will see in a little bit that the author can actually transfer that right to others. But at the core, it's the idea that if you wrote the original, if you created the original painting, no one else has the right to copy it except for you. The second right is the right to derivative works. It's the idea that you, as the author, have the right to make something based on the original, okay? So you can modify the original and create a new work. So a new work that's based on an existing work is what we call a derivative work, okay? So think of a photographer who's taken a photo and then decides that he wants to sell that photo on maybe as a greeting card. The photo is the original source. The greeting card becomes the derivative work. The photographer can make the greeting card because he already has the copyright in the original photograph. The third right is the right to distribution. And the right to distribution is the right to distribute the work to the public by sale, rental, lease, or lending, or even to give it away, okay? The fourth right is the public display right. This is the right to show a copy of the work directly to the public. So an example of this is, again, if we went back to that photographer and his photo and he decides to blow it up and put it into an exhibit at a gallery, he has the right to display his photograph, okay? And he can do it that way. That's a very physical display, isn't it? But he also has the right to put it on a website. He has a right to use it in a film. He can make it into a slide, or he can actually put it up in a television image at a public place, or to transmit it through television or the website to the public. So you can see that can be a very expansive right. The last right we're going to look at is what is called the public performance right. And this is the right to recite, play, dance, act, or show the work at a public place, or to transmit it to the public, okay? And usually the right to display and the right to performance can be very much interrelated depending on what that particular item is that's being copyrighted. So these are the 5 that we consider in our bundle of rights: the right to reproduce, the right to make derivative works, the right to distribute the work that you create, the public display right, and the last one, the public performance right. So as we talked about what copyright protects and does not protect, Let's talk again about what it does not protect. Facts, ideas, systems, or methods of operation. Although the law says that these may be protected in other ways, or the expression of them may be protected, but not them necessarily. And a good example of this would be a business plan for a business. Let's say you have a client who says, I have this idea for a business, this is my business plan. Well, the business plan itself, as a written literary document, would have copyright protection. But the idea of the business that's embodied in the business plan does not have protection, okay? So the idea of the business is not protected. What's conveyed in the business plan document, the document is protected, okay? So we have a couple cases that I'd like to go over right now. The first one is a California case. It's pretty recent, from 2011. It's Kim Sang versus J&A Importers. And what we have here is basically a bowl filled with ingredients of a Vietnamese culinary dish. And the court said, you know, that bowl with the ingredients in it is not sufficiently original, nor is it sufficiently fixed in order to be entitled to copyright. Now, people may ask, well, what about recipes in a cookbook? Are they copyrightable? What about the cookbook itself if it's just a collection of recipes? Well, we know that a cookbook of recipes is able to get copyright protection. The way that it's formatted, the illustrations that they may have on it, the format that they use to actually lay out these recipes. Some of the recipes may have protection if they pass that test that they have to be original enough, okay? If not, then they're not going to be protectable. Another case I want to bring up is the one called Utopia Provider Systems versus ProMed Clinical Systems. Now, this is a South District, Florida case from 2009, but I think it's very important because I think this case relates to a lot of, if we have business clients, this will be a case that's very important to them. Because what the court decided is that blank forms for physician recording of patient medical information are not copyright protected. And that's pretty much an accepted rule throughout copyright, is that blank forms themselves are not protected because what they convey is a system or a method of operation. And remember, in the law, that specifically says those are not protectable. So again, blank forms are not going to be protectable for that, okay? So what else can copyrights protect? Now, we spoke a little bit about that issue of derivative works, but what about facts? Okay, because we know that the copyright law says we don't protect ideas and we don't protect facts. Now, it's because of this that many of the news groups will be able to use images or the names of individuals or particular stories because, one, they're considered newsworthy, but two, they're considered facts, and facts are not protectable under the copyright laws because facts per se are not something that are considered original. They exist. They are what they are, okay? We have this case that focuses on that idea of derivative works and what's original and what's taken from something that already exists. This is a 2010 case. It's Mattel versus MGA. And in this case, it discusses about the issue of the Bratz doll. Now, the Bratz doll is one of these very popular sort of fashion dolls that girls can collect clothes for, collect accessories for. And the individual who designed the doll used to work for Mattel. And Mattel says, you know, actually this person, even though he went to MGA and MGA developed and marketed it, it's actually our property. It was a derivative work from something this individual was working for us on during his scope of employment. But the court has a big discussion about what a derivative work is, where did these Bratz dolls come from, and what were the original models. So it's just an interesting case to read, and it's gone back and forth. The first one, the first time it went to court, MGA won, which was the people who hired the guy after the fact and actually produced the Bratz doll. When it went to appeal, Mattel won, saying that it actually was their property based on derivative work. So we've had a little back and forth from that. It's an interesting case to look at, okay? One of the things that comes up a lot in copyright, again based on what cannot be copyrighted, is the concept of useful or functional articles, okay? And basically in the copyright law, a useful article is one that's defined that has an intrinsic utilitarian function. So it's not there for the art itself, it's there because it needs to be used. So let's go over some examples. The first one are utensils, forks, plates, mugs. Again, copyright protection is usually not awarded to them because first and foremost they have a utilitarian function. A cup, even though it may have an image on it, it's really about being able to put in a liquid and drink from it. Plates, to eat food from it. So you don't get a lot of copyright protection for those utensils. Now, there can come the time when something actually began as a piece of art, something that would have copyright protection, and then it was transformed or changed into a utilitarian article. So an example of this would be a statue that maybe after it was copyrighted as a statue and sold as a statue, somebody decided that they wanted to make a lamp out of the statue. Now the statue retains the copyright that it has. The lamp, because it's a useful article, is not copyrightable, okay? But the statue itself never loses the copyright that it originally had just because it was converted into a lamp, okay? Another issue that comes up a lot in terms of useful articles are clothing. You ever wonder when you watch the Oscars or the Emmy Awards and the women are wearing those particular dresses that were all designed by these brand name designers, and then probably by the next day or 2 days or definitely within that week you have all these knockoffs. And the fashion industry has been sort of really lobbying to be able to get protection for their designs, and the court keeps saying no, their useful article clothing is to cover the body, it's to be worn, and therefore it does not have protection. Now we do have some things that come up in clothing that sort of give us a time to pause as to whether it should have protection or not. One of those have to deal with costumes. What if something was created, so think about Mardi Gras, for example, or the Carnival in Brazil where they make these elaborate costumes. Would those then have copyright protection? The argument being that, you know, it's not really just to cover the body. It really is conveying a message through the costume, a very artistic value. And so the court has come up with this sort of test which she calls the separability test. Can you separate the artistic from the functional of that particular item? And in a costume, can you separate the artistic from the functional of covering the body? It's very difficult, isn't it? Even though you would say, well, that is definitely, you know, a work of art, the way that costume was created, the court can say, but how do you take that piece away from the functional aspect of covering the body? And this is where it gets very difficult to be able to get that copyright for those costumes, okay? Now this is different from when we're looking at items, although they may be clothing, that they're really for decorative purposes. An example of that would be a belt buckle. The belt itself is very functional, right? But the buckle, which can be ornate or decorated or ornamental, may not necessarily just be functional. So we do have some cases that say because the belt buckles are so ornamental, they do have a right to be protected under copyright. They're almost works of art themselves, and they're not really necessary per se. I mean, you can have a belt without a buckle per se. Jewelry, right, or though it can be considered an accessory, jewelry, hats, handbags, things of that nature, those again maybe have a functional part to them. So a handbag may be functional, okay, but the jewelry itself usually doesn't have any functional component. It's more for aesthetics in that. A hat, it could be functional, or it may be there just for aesthetics per se. A case that came up not too long ago, actually in 2011, that sort of was very interesting, had to deal with Louboutin and his red bottom shoes. Now, he is very famous creating women's heels that have painted red on the bottom of the shoe throughout all the way up to the heel. And there was a case where he was trying to protect that part of it, that red bottom of the shoe. And he actually lost that case to a competitor who started to also paint the bottom of his shoes red. And the court was saying, well, again, a shoe cannot have copyright, and you just cannot copyright a color. But it begs the question, because we do have another case, another situation with the Tiffany store. And if you've ever seen the Tiffany store, and when Tiffany wraps something up, it usually has this very specific blue. In fact, it's called Tiffany blue that it uses. And it actually has not a copyright in the blue, but it has a trademark in that blue color. So no one else can use that blue color, because it denotes, when you see that blue color, it's actually telling you that the source is Tiffany. And so Louboutin was saying, well then, why can't I use that as well for my red bottom shoes? And so that's still an appeal. We'll see if there's any change at all in that case. But for right now, he did lose, and his competitor is allowed to also paint the bottom of his shoes red. The last thing that I want to talk about, used for items, actually deals with furniture, chairs, tables, different lamp structures. And again, the court is saying, well, these are utilitarian, right? You have a chair, it's to sit on. You have a table, it's to place things on or to eat things. And then we have designers who say, yeah, but these are very specially made. They have an artistic, aesthetic value when we put these pieces together. And right now what we have are the court saying, well, then you need to get what is called a design patent for that. It's not covered under copyright, because they're specifically said we do not cover those things in copyright, but you can try to get protection under a design patent, which is a lot more complicated and only gives protection for about 17 to 20 years, which is very different from copyright that can usually last the life of the author plus up to 90 years, okay? So that's a big difference between 17 years in a design patent and, over 90 years when you have copyright protection there. So just a thing to think about. So another area of copyrights deals with architectural work. And when we talk about architectural work, we're talking about the design of a building as embodied in any tangible medium of expression. So that can be the building itself, because it's built, you see it. It could be the architectural plans, or what we might call the blueprints, or it can be a drawing of the building, okay? Now, with the plans and the drawing are protected. Not the building, because the building hasn't been built yet. It's still an idea, okay? So the plans and the drawings are what are protected. The building is protected once it is built. And people say, well, wait a minute, because a building does have a functional role, doesn't it? I mean, it's to house people, or it's to house office space or stores. but the courts look at architectural work as being something of a very creative endeavor, not just the fact of putting bricks on top one over the other, but really laying out sort of a plan and a very aesthetic value that it would have. Now, saying that, there are two sort of limitations on that right with architectural work. The first one deals with pictorial representations, or more or less now, because most people will not be drawing a building, but taking a photo of a building. If the building is located or is ordinarily visible from a public place, you can take a photo of it. Okay, so you walk down, a street in Manhattan and you see the Times Square and you see that there are lots of photos of that being taken. Okay, and people will take a photo of that and they'll put it up. The other restriction is that the owner of the building may alter the building itself, or they can even destroy the building, and the architect will have no recourse. They can't say, you can't do that, you can't destroy the building, because it is the owner of the building who owns the building and can determine what they can do with it, even though the author of the building was the architect. His rights are limited by the rights of who actually owns the building. Okay? The last group of items that I just want to point out have to deal with government works. Okay? Things that are written and put out by the government, whether it's the federal government, a state government, or a municipal government. It's the idea that anything put out, so reports, budget reports, different kind of white papers that they might put out, those are not protectable because they're done by the government. Instead, though, the laws do say that the U.S. government can receive and hold ownership of copyrights if those copyrights are transferred to it. And an example of this would be through the grants process. Some universities and colleges will receive grant money from the federal government to conduct research, to maybe look at inventing certain things, pharmaceutical drugs, or things that may be helpful, inventions that may be helpful in commerce and industry. And part of the granting of those funds will be a requirement that the government is the one who is going to retain any copyrights that there may be in what is developed or found there. So those are basically some of the big items that would be covered in copyrights and the items that are protected: government works, architectural works, and then also what's not protected, things like useful articles, like the clothing and the utensils that we just spoke about. Okay, so now that we looked at what kind of works are protected and what kind of works are not protected, let's also talk about some other basics of copyrights. One of the questions that always comes up is, when is the work actually protected, or does it have to be registered with the U.S. Copyright Office first? So the first question, when the work is protected. According to the copyright laws, your work is protected at the moment of creation. Now, that seems to be pretty straightforward, right? I write something, I created it, it is now protected. But for some of those, and for example, the visual arts, how do they know when something is created? Is that the same thing as saying that something is completed? So for example, is a work of art, a painting, protected throughout the stages of having it created as a work in progress, or is it only protected when it's completed? And this can be difficult for those in the artistic world, because sometimes they may do a painting and they may think, okay, it's done, it's over with, and yet a few months later or even a year later, they may go back and tweak it, trying to make it even better. So when did copyright actually affix to it? Well, it said as soon as it's created, it has it. And as soon as you start creating it, we believe that it has it as well. So that work in progress, every stage of it, it is being protected. Now, do you have to register with the U.S. Copyright Office? Well, the answer is no. Registration is actually optional, okay? But, or what they say that registration is voluntary because copyright exists as soon as you create the item. However, there are reasons that you would want to register the item that you created. One of those reasons is if somebody copied you and you want to sue them, you want to have a lawsuit. Well, one of the requirements that we have is before you can even have the lawsuit, you must have that registration, okay? So I want to go through the steps of registration. There's actually two ways of doing it. You can do a paper registration that you fill out. You can get the form right on their website. You can fill it out and then you can mail it into the Copyright Office. If you're in DC, you can actually walk it over to the office. Or for most of us, what makes it even easier is that you can do an electronic application for registration through the new ECO system, or Electronic Copyright Registration System of the Copyright Office, okay? Now, if you do it by paper, you need to make sure you have the right form. So, for example, the copyright form TX means that it's going to be a text or a literal work. The copyright form VA means that you want to get copyright protection for visual art or 3D sculpture, for example. When you do your registration online, actually what happens is that it goes through a series of questions and screens that it wants you to fill in, sort of like fill in the blanks. So instead of trying to decide which form to use, you'll actually check off on a list what type of item you are trying to protect, okay? Now currently, the fee for a copyright registration is $35 for a single. Now again, depending on when you view this particular session, it's always a good idea to verify before you tell your client how much it may be. The other way to do it is if you're not doing a single item registration, you might be doing a collection to be registered, and the collection itself would be registered as a single collection per se. So you would pay $35 for that collection, and this is done a lot with like musical compositions on a CD, or maybe if it's a collection of ornaments in a particular year for a particular holiday, you might register the collection instead of registering each and every single ornament. So it's one way to save money for your client, but the client has to realize that then all those items make up that collection. Okay, so they want to be very specific as to what they may call that collection, so it's very clear what it is that they are actually registering. Now, all registrations will require a deposit. It used to be, when this started off basically for published books, you would require 2 deposits or 2 copies of that published book, and that would be sent to the Library of Congress. The idea that one of those books would stay in the Library of Congress. It used to be really cool for authors to be able to go to the Library of Congress in DC and sort of ask the librarian, oh, I want this book that they had written, and they would actually be able to see their book at the library. Today, though, what we're seeing is much more electronic deposits of items. So let's say it's a painting or a photograph. It would be an electronic file of that painting, so not the actual painting, because there's only one of that painting, right? But you would take a photograph of the painting, that would be an electronic file, that would be the deposit. It is uploaded through the electronic system at the Copyright Office, and that serves as the deposit. Now, one of the great resources that the Copyright Office website actually offers is a series of brochures and pamphlets that talk about how do you copyright specific items. And so you should go there. The Copyright Office website is www.copyright, www.copyright.gov. Again, that's www.copyright.gov. And just click on, informative pamphlets and brochures, and you can see the wide range of information that the Copyright Office has for you. And that can really help guide you when you're registering this or helping guide your client. So it's a great resource to have at your fingertips. Okay. Now, some other issues for copyrights that I'd like to talk about, and these are a wide variety of just supplemental issues that are important to know when you're dealing in this area. The first one is what we call the public domain. And the public domain is sort of this imaginary space where items that their copyright has expired or items that never had copyright sort of exist, and that then individuals can reuse them or use them or make a play on them. Now, because we've had different revisions of the Copyright Act, and depending on which year the item was actually created and registered, when that item goes into the public domain can be a very complicated calculation. So right now, because of the year that we're in, a good estimate is that anything that was created before 1923, whether it's a book that was published, a film that was created, a recording that was made, or a song that was written, anything before 1923 is sort of considered to be in the public domain in the U.S. And the public domain is very important because the court also realizes that we do not create in a vacuum. If you think about how many pieces of input we're bombarded with every day from commercials and billboards and emails and talking with people and watching TV or seeing a film, all of these different inputs work inside our minds, are manipulated and sort of processed, and from there comes this creative intellectual property that is created by this person. And so the court says, we need public domain because we need people to be able to go and build upon what has come before. That's why the Constitution says it's for a limited time that the authors have these rights, not saying that it is perpetual, that they're going to have these rights forever. So that's why the public domain is very important. Sort of similar to the public domain is this idea of the Creative Commons license. There are some who work in the creative industries who believe that copyrights last too long, that they actually prohibit this idea of creativity occurring, and that in fact it should be shorter, or that copyright laws should not exist at all. And so from there we have this Creative Commons license, and the website is on your handout, creativecommons.org. And it's sort of like an honor system. It's the idea that you put something out there, you say, I'm granting a Creative Commons license. And basically what that means is that the person who's going to use the work that you put up there must use it exactly as it is, must credit the source, and cannot then, manipulate it, turn it around and saying, oh, this is mine, and sell it off, okay, or license it off. Because the idea of the Creative Commons license is almost like open source in software. It's the idea that we're going to share this. Nobody is going to transfer any kind of financial incentives. So it's a really interesting development that has occurred, and you might want to take a look at it again. That's creativecommons.org. Okay. The other question that comes up is, do you need to put a copyright symbol, that little C in the circle, in order to have copyright protection? Well, at one point it was required, but since the laws have been reformed, right now the current version of the copyright law says you do not need to have the copyright symbol because, again, copyright is automatic. But I always tell my clients that it is a good idea, a best practice for them to put that copyright symbol and the year, the name of the company, or their last name and the year, just to keep people on notice. One of the problems that we have, especially online, is that individuals they just assume that whatever out there is free, that they can cut and paste, they can do whatever they want with it. So it's always good to have that symbol to sort of remind others that in fact this content and the data that's out there belongs to somebody. You might even have on certain websites a copyright policy which states, you know, that exactly of what I talked about, that this content belongs to somebody, that if you want to use the content or copy the content or republish the content, please write to us to request permission or consent, okay? So you might want to take a look at some of the websites and just look at their copyright policy and see what they have there. Now, we've talked a lot about what gets protected, what doesn't, how long it gets protected, but another issue we need to discuss is this idea of who an author could be. Now, the basic understanding is the author is whoever created the work. But there are some instances when that work and that copyright is not owned by the person who actually created it. So we have the situation of an independent contractor versus an employee. And this falls into what we call the work for hire doctrine. Now, most of the time, it is accepted that anything an employee does or creates within his scope of employment is considered to be owned by the employer, not by the employee. With independent contractors, it gets a little bit more blurry, the line. And so one of the things you have to be careful about is in an independent contractor agreement, the contract that they actually sign, whether there is in fact a work for hire paragraph or term or clause, and whether it talks about a transfer of copyright. So the idea that the independent contractor is being hired to produce or create this item for the person who is paying them, and therefore they do not own that copyright, but they have transferred it, given it over to the person that they created it for. So a good example of this would be a jingle that is created for a company by, you know, another ad agency or another company, or by a composer, and there is a work for hire clause in that contract that they signed with them. This comes up as well with commission works in the visual art category, where artists may be doing something, a piece of public art, they're being commissioned to do this, and again, they're going to sign over their copyrights in the item if it's in the contract. If it's not in the contract, then they retain the copyrights because they're not an employee. So the big question becomes, how do I know if they're an employee or an independent contractor? Well, most of the cases basically fall on whether the company paid taxes for that particular person. So if that company withheld taxes for that individual before they gave them the check or the compensation, the court will more likely rule that that person was actually an employee of that company, versus if they were just given a straight check and the individual was responsible to pay for his taxes, then that's usually much more likely to be ruled as an independent contractor. So you want to take a look at those facts very specifically. Now, in the copyright law itself, it says that there are only about 7 categories of work for hire. Includes a film, for example. They do not put musical compositions, but we know that some, like studio musicians, would not be considered to hold a copyright. They would be more like work for hire. You were hired to do the drums for this recording, but you do not have ownership in that particular item. But we'll see more of that when we discuss music law in a little bit. Okay, so besides the fact of who the author is, if you are the author, you have some options as to what to do with your rights. So you can transfer your rights by selling the rights outright to somebody else, or licensing the rights. And what's interesting about licensing is that you can actually license bits and pieces of your copyrights to limit them by specific time period or limit them by a geographic location. So these are what we call non-exclusive licensing rights that you are handing over. So a good example of this would be an author who wrote a book. He can then sell the movie rights to that book to a movie studio. He can sell the rights to make that book into a play, to be on Broadway, for example, a musical. Well, that would be a separate series of rights. If it was to be an animated series, that would be another separate series of rights. If it was to be an animated series in Asia, well, now that's another series of rights limited by geographic location, and maybe will be specific by language as well. So the English versus Malaysian, for example, versus Spanish if it was done in South America. So what you see is that these rights can basically be split and divided up, and that's part of the value that they have in there, okay? But remember always that rights depend on the country that the work was produced and or registered in. So, you know, registering a work in the US may give you a certain rights. Registering a work in the UK may give you others. You may not be able to register in the UK. You have to see what the requirements for eligibility would be, okay? So now with that in hand, let's talk a little bit about infringement. And infringement is when one of your bundle of rights, of your copyrights, has been violated. Now, some of you may have heard the term plagiarism, right? The idea of taking credit for someone else's writing. Well, one thing to keep in mind is that plagiarism per se is not a legal term. You can't sue somebody for plagiarism. You can sue somebody for copyright infringement, but not for plagiarism. Now, when we look at somebody, you know, suing for copyright violation, there are certain things that have to be proven. One of them is access to the original material. And then the second thing to be proven is substantial similarity between the original and the copy. So much so that everybody knows that the copy was copied from the original. That's what's really important there. The other thing that comes into play are statutory damages. Now, this is where, if you remember, we were talking about, do we need to register our copyright? And I said, you know, you're not required to, it's optional. If you're going to go into a lawsuit, you do. The other important thing about registering is if you register within a timely manner, and for the copyright law, that means, you know, within 3 months of publishing what you created, if you register within those 3 months, what you do is you reserve the rights to statutory damages, and that in fact can be attorney's fees or a certain amount. So we're going to look at that in a little bit. So that's why it's so important to register within a certain amount of time. Okay. Let's take a look at some other issues with copyrights and what may be deemed, well, reasons why copyright violation would be justified. One of these is the idea of appropriation. Now, appropriation, the idea that you take things from something else and put it into your work, okay? Different from a derivative work where you start with an original and take away from that and create something new. This one, you're sort of taking different items and making a brand new one. Comes from a property right called the first sale doctrine. The first sale doctrine says that if you buy something, you can do whatever you want with it. It's yours. So if I bought this pen, I can do whatever I want with the pen afterwards. I can sell it to somebody else. I can give it to somebody. I can break it, or I can just use it until it's no longer has any ink. I can do what I want because I bought it. And in certain circumstances, when it comes to copyrights, that issue comes up. So we have, for example, some visual artists who might make collages based on items that they have bought before, whether it's, you know, pictures from a children's book and then they create a new painting or a new mixed media out of that. That's where it's going to come from in there, okay? Another justification is what we call the fair use doctrine. This comes in section 107, originally in the 1976 Act, and there's actually a four-pronged test from a case called the Miller case. And what it looks at first of all the purpose and character of the use, the nature of the copyrighted work, the amount and substantiability of the portion used in relation to the work taken as a whole, and the effect of the use upon the potential market or value of the copyrighted work. So these are the four factors that the court will look at to see if fair use is in fact appropriate or not. Okay, so we looked at that four-pronged test for fair use, but the law does sort of give us some guidance in sort of listing some activities that can be considered automatically fair use. So some activities that are deemed okay would be, for example, small excerpts that are used in a review or criticism of the work itself. So we see this a lot on book reviews, for example, where they may take 2 or 3 sentences or even a couple of paragraphs. They're not taking the essence of the book, they're not taking the entire book, but they're taking just enough to sort of illustrate some of the reasons behind their criticism or their review of it. A short quotation in a scholarly work or technical work. Again, maybe a report that's going to come out to justify a certain course of action, and so it'll take an excerpt from reports that are out there and put it into this report to sort of illustrate why this is a recommended step. A clarification of an author's observations, for example. So somebody being interviewed about a book or an artwork that they may have done, and their quotes or their explanation or sort of included in the review, just to be able to clarify what were they thinking when they did that or when they wrote that book or that article. Another fair use would be if it's used in parody or as parody. And we have to be very specific here because there is a difference between something used in parody and something used as satire. Parody is something that is being used to make fun of the original, okay? Satire is using something to make fun of something else. Parody is considered fair use. Satire is considered a violation if you do not have consent for it. So an example of parody would be in, a couple of races ago, we had Sarah Palin, who was running as vice president, and we had a comedian, her name was Tina Fey from Saturday Night Live, and Tina would impersonate Sarah Palin in some of the skits on that show, and that was considered a parody. And it was important that Tina Fey looked and spoke and acted enough like the original Sarah Palin so that people could understand where the humor was going to come from. An example of satire, again looking at the political elections, was a political campaign who used a song and then changed the lyrics to the song. Okay, so they used the music but changed the lyrics to the song to sort of emphasize their message. And the court said, no, that's satire. You're not making fun of the original song. You're making fun of another candidate. That's satire. That's not parody, and therefore it is not protected under fair use. So very important to understand the difference between parody and satire when it comes to copyright and when it comes to the fair use defense. Okay. We may also have, for example, the use of fair use if it's a summary of an article in a news report. So this almost fits in with that review or criticism issue that we looked at before. If it's being summarized and being broadcast on a news report in a news show, then that's considered fair use. Another thing that comes up is what some people may call an educational exception, the idea that teachers can use certain items when they're teaching in the classroom. Well, it's not as easy as just saying, well, if a teacher is using it in the classroom, it's fair use. There are certain conditions that have to be met. One of those is the idea that it has to be spontaneous, okay? So if a professor or a teacher saw something in the news that morning and made copies of it for his class to discuss in class that afternoon. The idea that it was spontaneous, it just came out, he's bringing it into the classroom. But what we're seeing now is with technology, most professors will just give a link to the article to their students so that the students can go and get the article instead of him just bringing it in and copying it for them. We also do have what's called the Digital Teacher Act. And the Digital Teacher Act is sort of looking at, well, what if you don't have things that are in digital format? What if they're only analog? What if it's an out-of-print book? Can you make copies of that for, scholarly research? And one of the new functions that we're seeing many librarians take on is this idea of clearances of rights to be able to use these items in a classroom, especially if it's, an article or a book that a professor has been using year after year after year. They really do have to get a clearance to be able to use that so that copies could be made and distributed to students, especially if it's something that's out of print. So what we're seeing is a lot of librarians, are taking on that role of helping to clear the rights so that professors can use work. So again, don't assume that just because you're a professor or teacher that you can photocopy something and just hand it out. You want to see, if it's owned by somebody, the idea of getting reprints, etc. For businesses, if their business comes out in a newspaper, for example, and they're highlighted in that newspaper, can they then go and photocopy that newspaper article? Well, technically, no. Technically, that would be copyright violation, which is the reason why many newspapers and magazines actually have reprint services where they can then order reprints of that article for them to use legitimately and legally. Now, one of the things that your clients can do, though, is if they are portrayed or profiled in a news report or in an article, to ask that source whether they can link to it by their website, whether they do have permission to make certain copies, but don't just assume you have the right to do that just because it was a story about your company. It's still copyright protected. The author is that news source, not your company, even though the story was about them. So just something to take a look at. You can link to the news source, but you just can't copy and paste it onto your website. Okay. Now let's talk a little bit about remedies. We saw some of the ways that you can, have violation. We saw some of the justifications or defenses for violations. But what about what you can receive if violation is proven? Okay. Well, the first thing is this idea of injunction, meaning to stop somebody from doing something that they may have done. So to stop somebody from continuing to copy your item or continuing to broadcast the property that you made. It might be, if you have timely registration, statutory damages. So, the law says anywhere from $750 to $30,000 per violation right now. But again, you want to check with the laws at the time that you have the case to see if that might have changed in any way. You may have willful infringement. There are no punitive damages per se in copyrights, the idea to penalize somebody. But if you did register within that 3-month period and you can prove willful infringement, the court will actually award up to $150,000 at their discretion to the plaintiff. So again, another reason why that timely registration is so important. If you do not have timely registration, then the court says your only recourse is to then ask for actual profits. In other words, the infringer cannot be unjustly enriched by their criminal act of infringing. But this can be, number one, very difficult to prove what the actual profits are, because it's not just the revenue that was made, right? So let's say, you're an artist and they put a picture on a t-shirt and they sold the t-shirt for $20. It's not just how many t-shirts did they sell. Let's say 100 times 20. Well, that means you're entitled to $2,000. No, what the court said is it has to be actual profits, meaning if it was $2,000 in revenue minus whatever they spent in development, minus whatever they spent in producing the t-shirts, minus whatever they spent in marketing the t-shirts, minus whatever mechanism they used and cost for that mechanism to actually sell it or ship it to the customer. So those $2,000 you can see very quickly dwindling away to maybe a couple of $100. And this is why it is such a decision whether to do copyright litigation or not for that particular person who has been violated. Because very quickly, if they don't have that statutory damages reserved because they didn't register timely, what they may get back may not even pay for the legal fees of the attorney that they're hiring, or the court fees, or just the litigation fees per se. So it's very important that you talk with your client about what is reasonable to expect in getting back, even when violation is proven, versus what they can actually get back in damages, okay? And so, you know, one of the things that might be a good practice is the idea that if something does come up, start with a cease and desist letter to who is considered the violator or the infringer, okay? The idea that, you know, you send this letter, you say, I represent this client, he has copyrights in this, we reserve our copyrights, we protect and enforce our copyrights, you know, you are in violation of them, we ask that you immediately cease from your activities, so on, so on, so forth, and always end with that you reserve your rights to the full remedies and full extent allowed by law. And send off that letter and see if they will actually stop what they're doing, or they may, you know, reach out and say, we didn't know it was owned by you, and sort of resolve the issue before you have to go into a court litigation and spend that time and spend the resources to go through that. Because with litigation, you're going to need to have to file a complaint. If you are going to do an injunction, you must do a motion for a preliminary injunction, and you must do a brief in support of that injunction, because you're basically stopping somebody from doing something. You're asking the judge to pass an order to stop this person from doing something. And so sometimes the federal courts will actually require a bond in the amount of whatever monies might be a loss for that other company because you put that injunction in. So do look at the procedures of the particular court that you're going to be filing in to make sure whether they have that requirement of a bond or surety or they don't. So again, deciding to go into litigation for this is a decision that has to be made by the client with full understanding of what they may or may not reap at the end of the day. Okay? So the last thing we're going to be looking at today are some of the issues that relate to copyright infringement or copyright protection and online platforms. Now, when you use an online platform, most of them right now are being used as social media platforms like Facebook, Twitter, LinkedIn, Quora, Foursquare, etc., etc. I mean, right now there's over 200 of these platforms. Most of these platforms do have what are called terms of use or terms of service, and it's important to review these terms of use before you put any of your content up, because some of these terms of use actually do say that by putting up your content, you are granting that third-party provider an unrestricted, unlimited, worldwide license to then reuse the content that you put there, or for them to license it off to somebody else, okay? In these terms of service, they also talk about how you, by putting up the content, are also warranting that you own the copyright to this content, that you are not stealing this from somebody else, and that if you are, you will indemnify or hold harmless this third-party provider there, okay? Now, some of these platforms have tried to educate their users on this idea of copyright infringement. So YouTube, for example, now has an animated squirrel who's dressed, you know, he has a pirate patch on one eye and a wooden leg, and the idea of being the anti-pirating squirrel, and sort of a little animated feature that talks to people about copyrights and what you should and should not do. A new issue that has come out is a new social media platform, Pinterest. Now, what's interesting about Pinterest is that it was introduced in late 2011 and it's really taken off. I mean, right now it is the third most common social media platform after Facebook and Twitter. Pinterest is now the third. It superseded LinkedIn. But there is a big concern with Pinterest because what it allows you to do is, if you think of a bulletin board that you might have in your office, you might have some magazines, cut out some articles, pictures that you liked and sort of pinned it on this bulletin board. Well, Pinterest is supposed to allow you to do that electronically. So as you go and visit websites on the internet, if you see an image you like, that you can pin it and put it on your electronic board. Now, technically, this could be seen as copyright violation because you're copying something that does not belong to you, copying something that you do not have access to. Now, people say, well, you know, it shows the source of where it is, but showing the source does not justify the conduct, right? Just because you know that it's somebody else's does not mean you didn't violate by copying it and putting it someplace else and using it. So right now with that controversy, we're going to see what happens with Pinterest and copyright. It's been a lot in the news. We don't have a lawsuit yet that deals with that, but we will see where it comes up later on. If you remember, and this is very important with these third-party platforms and ISPs or Internet Service Providers, I mentioned the DMCA, the Digital Millennium Copyright Act. And one important section that they have there is what is called the Safe Harbor provision. And it says that these third-party platforms like YouTube, like Facebook, are not liable for copyright violation that is done by their users. It is the user who is in violation, not the platform. Now we have this case of Viacom versus Google, and it's Viacom is the studio that has a lot of content, TV shows, movies, things like that. Google owns YouTube. So really Viacom was suing YouTube, but since Google owns it, it comes out Viacom versus Google. And Viacom was suing YouTube saying, you know, people are putting up episodes, full episodes of our TV show, and that's a copyright violation and you should be held liable. Well, the first round of that court case actually brought in the safe harbor provision, said YouTube was not responsible for what the users were doing. They have the safe harbor, they are not liable, okay? But we've recently had an appeal in that case which says, you know what, YouTube may in fact be liable. So this is something that we're really looking into. You know, we had that first decision in 2010. Now we're seeing that it's taking a different direction. So it's definitely a case that you need to watch out for and look at carefully. If any of your clients are an ISP, an internet service provider, or one of these third-party social media platforms, or if they are a company or a content provider trying to seek protection, okay? Another thing I'd like to bring out is we talked about the first sale doctrine, right? The idea you can buy a book, whatever, once I buy the book, I have it, it's mine, you know, I can physically give it to somebody, sell it at a flea market, whatever. But it can be very tricky in this digital age because, for example, one of the things that keeps coming up is, can you resell an ebook, an electronic book? Can you lend somebody an ebook, an electronic book, right? You read a book, you tell your friend about it, your friend says, oh, can I borrow the book? You physically give them the book. One of the things then is that you no longer have physical possession of the book, right? Your friend has it. There's only one copy, and you transferred it from you to your friend or your colleague. In the electronic version, though, if you were to just give them a copy, actually you end up with two. And since in the digital world this copy is as good a quality as the original, it makes it very hard to say, well, how do I make sure you then delete the electronic copy from your reader and that there is only one copy here instead of two people being able to enjoy that. So there's a lot of controversy that is still going out there, okay? Because of the issues of violation of copyright online or piracy of copyright, late last year we actually had two bills that were introduced. One in the House of Representatives, which was the Stop Online Piracy Bill, or SOPA. The other one was in the Senate, and it was Protect Intellectual Property Act, or PIPA. Now, you may have heard of this because in January of this year, we actually had a web blackout that were related to the SOPA and PIPA laws. And you may have seen many websites like Google, for example, Wikipedia, others of these websites, YouTube, sort of either become totally black when you went to their website or put up a sign saying censored or anti-PIPA, anti-SOPA. And the idea, you know, they say that these bills really pitted Hollywood or these content providers, movie makers, the recording industry, who really wanted these bills, who want to protect their copyrights in the film and the music, et cetera, against these technology companies like Google and Yahoo and Facebook, who offer these platforms to individuals to be able to share information. One of the biggest issues that happened with these laws is that for the first time they wanted to sort of restrict that safe harbor that we had in the DMCA, and they wanted to also sort of include a 5-year prison sentence for executives of these platforms. And so these platforms were quite concerned about that and having to go to jail for certain things like that. And so they really reached out to the internet, to individuals who were using these technologies and said, hey, this is what can happen if we don't do something. And so they had the blackout in January, and the laws did not pass for that. But people keep asking the question, you know, so much can be pirated online. What do we do to prevent it? What do we do to make sure that content providers get protection in what they produce? And so we're continuously looking at that, and Congress continuously looks at particular bills to see what they can do. Now, there was another bill that was passed in April of 2012, and it's called CISPA, the Cyber Intelligence Sharing and Protection Act. It passed the House. It is now on its way to the Senate, but President Obama has said that he would veto this bill along the same reasoning lines that PIPA and SOPA were considered to be not acceptable to the public. So it was introduced at the end of November of last year by Representative Michael Rogers, and had about 111 co-sponsors to put this, but again, Obama has said he will veto. We'll see where this particular law actually gets to. But it is something that is continuous, because there is this sort of conflict between those who create the content and then those who have the channel to distribute it, to make sure it gets distributed but the value stays intact, because that's what the copyright laws do. They protect the value of that intellectual endeavor for your clients and for the businesses. So that is our introduction to copyrights, and just giving a preliminary foundation where it all begins in terms of intellectual property protection in the U.S. If you have any questions, you can always submit a question right online or go to our website and you can see us there. But that's it for now, and I'll see you with our next session. Thank you.